Right. Welcome, audience, to our second session of our conference. As I talked before, and I introduced myself as Malebakeng, Forere from the University of the Witwatersrand. I teach intellectual property, and I like it a lot. So in this session, it's a session for lawyers. We're going to, in the first session, we have heard of the people who are at the coal face, the people who are dealing with IP issues, the people who are impacted by IP. Some of us do theorize about IP in our high offices, but these are the people who work with IP. And so the lawyers have listened to you, and they are going to respond in some way to some of the concerns that you have raised, So as you know, IP, it's a subject that dates back to the 18th century or 19th century. So it's quite old. And even when you look at the international instruments, they are very old. The Berne Convention is an 1884 instrument and hasn't been amended, many times. And African countries, as you know, we inherited our IP legislations, and in particular today we are focusing on copyright. So we inherited our legislations from the countries that colonized us, and obviously the laws in our respective countries are very old. Many of them predate technology, they predate internet. And today when we talk about research exceptions, research techniques. We talk about things such as text and data mining, which is what this panel is going to talk about. And the question that is critical for the lawyers, the speakers today with me, is to what extent do copyright laws in Africa do allow modern technologies of undertaking research, such as text and data mining? So I'm going to give each one of my speakers 6 minutes strictly. And I'm going to start with Professor Sean Flynn next to me here on my left. So he is a professor in the Washington University in the US. He is the director at the Information Justice on
Information justice.
Yeah, information justice and intellectual property. Yes. So he's the director there. Him and his team, and I think the video that Ben showed to us earlier on, just before the break, as part of the work that he has been doing with his colleagues overseas. So they have undertaken a global study in which they were looking at the extent to which countries have enabling exceptions, to undertake research. So Prof. Flynn is going to share with us that data, and he's going to show how Africa, the openness of African countries in relation to other regions in the world. And the time now is 12:25, and at 12:31, I would like you to wrap up or to come to an end.
I think I'm going to go 30 seconds over just to see what happens.
Okay.
But I'm feeling very restricted and disciplined, so I will try to be on time. So, as Malebakeng mentioned, especially in the developing world, but really every country receives its copyright laws from somewhere else. And a prime instrument for that exportation of copyright laws into other countries is, as Malebakeng said, the Berne Convention. That was originally drafted in the 1880s. It's called Berne because it was drafted in Germany. It was drafted by European countries at the time. None of your countries were part of that, right? And that convention requires that we all have certain kinds of copyright laws. But actually, the one in the 1880s, the only copyright law you weren't required to regulate a copy. You were required to regulate publications. It required that you have a right to publish works. not to reproduce, not to copy. That wasn't added until the 1970s. And at that time, all the European countries had education exceptions and research exceptions. Those were the two most important exceptions. And they were written into the Berne Convention. In fact, it was Germany, the country that was hosting the conference, that said we will refuse to sign on if you don't have research exceptions in particular. That was the country that pushed for them. But in that original Berne Convention, because it only applied to publications, it only had a research exception for publications. It said you could use excerpts and quotations of other works in your research or education publications. So can I ask you to turn on the slide, whoever is running the video. This is a map of what our research exceptions look like today. The red countries still only have the research exceptions from 1886. They have an exception for the use of quotation or excerpts in publications. Okay, now think about what Vukosi was doing. Is he only using quotations in a publication? He's doing neither, right? He needs to reproduce and mine with computers entire works, right? Newspaper articles written in African or English languages, right? These materials from the Jehovah's Witnesses that are written in every single language in order to train machines to translate materials. So is he doing research? I would say yes, right? He's using a product for a research purpose, not a publication purpose. But in the 1970s, the Berne Convention was amended not to require just publications, but reproductions. But when it did that, it didn't have an explicit mandatory exception for research. So many countries didn't update their exceptions. Or if they did it in a multiplicity of ways. And so that multiplicity of ways is what's described here. And there's the article that describes it is floating around. But so quickly, I'll just describe it and then move on, because I'm not looking at how many seconds I have left.
You've got 2 minutes.
2 minutes, perfect. The green countries have what we call an open research exception. It applies to any kind of work. It doesn't have to be a literary work. It could be an audiovisual work. You could mine television shows. You could mine those radio programs from the SABC, right? So any kind of work. It applies to any kind of user. You don't have to be part of an educational or research institution. You can just be an individual. Somebody mentioned journalists. You could be a journalist. And importantly, it applies to whole works. Whole works. The use of that work has to comply with some kind of proportionality clause that protects the right of the author. You can't just republish those works, for instance, and take away the market of the author. But at least in the green countries, you can use a whole work of any kind by any kind of user for a research purpose, but only the green ones. The red countries are those ones that have the 1880s type law. They're really only thinking about uses in a publication. They only authorize quotation. So you can never use a whole work. So basically any kind of digital research using and reproducing a whole work would not be permissible in the exceptions in those countries. And all the other countries have some kind of restriction. So in the dark blue countries, you can make a reproduction, but you can't share that reproduction with another researcher. So you can't do collaborative research, certainly not cross-border collaborative research. In the light blue countries, you have to be an individual. It's a private use right. It's the right of only an individual, which also implies a disability to share that item with others. And then in the, what color is it here? I think it's, in this one, it's the blue countries have restrictions on different kinds of works, and the yellow countries have restrictions on sharing. I have different kind of copies on this. But the point is, if you're not a green or a red country, you really have to look into your law to figure out, with respect to a certain project, can you use a whole work or not? So many laws, for instance, say you can use an article but not a whole book, or not a database, or not a computer program. So different kinds of restrictions on works. Many laws say you have to be in a research institution or a library, you can't be an individual. And so these are things, as we're updating, one can think about, is if we're adopting these kind of open research exceptions. And if you have, then it may be a process of translating and explaining what rights exist to the researchers who don't always know, right? There needs to be some kind of partnership between lawyers and researchers to help understand what might exist. So I think I'll wrap up there, and we can come back to some of this.
Yeah, I mean, I like that, the last sentence, you said that for these blue countries, you need to explain to the researcher what rights they have. We have heard of the story that the Masakhane project is encountering. So right now, we are going to hear to Dr. Melissa, who is going to tell us what rights do they have. I mean, how would you explain to them about the kind of rights that they have? Yeah.
Thank you so much, Prof. It's also a pleasure to be here, to finally be in a room full of lawyers, to feel comfortable, right? Most times when I talk about this, I'm the only lawyer in the room, and then everybody comes for me. But now there's a full panel of lawyers that you can come for. I think it was an interesting situation when Masakhane came to CIPIT. CIPIT is, first of all, a research-based organization in a university. We're housed in a university, so our core business is research. And Masakhane, we worked with them in a research sort of aspect, but then they come to us with this problem, and the answer to the problem that I had, putting on my lawyer hat, because you can be a lawyer and an academic, those are two different things, was it depends. And what does it depend on? It depends on what copyright attaches to the work. And once we determine that, then we understand what exceptions can apply, right? And we've heard about fair use, and you've heard about fair dealing, and we can see that there are different countries that apply different rules to these exceptions to copyright, because copyright is a general rule, and fair use and fair dealing are exceptions. And what is it that they were doing? We were all agreeing that it was research work that they were doing. We sort of battled a little bit to understand what will the end product of the research be. Will there be commercial use? And this is me like looking at Kathleen and smiling, hi, at the end of it. So if it's strictly research, then we have to say, well, fair use would cover it, fair dealing would cover it. This was Jehovah's Witness. At the time, Jehovah's Witness, if you looked at the website, it said that it was copyrighted care of Pennsylvania, right? That's in the US. But there was also something else interesting on the website. They had a copyright notice. You could click on it and read what do they allow you to do and what don't they allow you to do. This is even before you think about fair use. And they really laid it out that they do not allow text data mining. It was clear that we don't want you to do this. So that means we would have to rely on the exception, meaning fair use. But now I had to think practically also. This is Masakhane, we're based in Africa. Or they are based in Africa, let me not assume personality of Masakhane. And what is the goal at the end of the day? If we are going to test it, and you've heard about it, where is Vukosi? Vukosi is being tested and asked to test these rules in court. Do they have the time? Do they have the resources to do that because they are actually funded? Do the grants allow them to test this in court or not? And the time, we didn't have enough time to even think about these things. So the best thing to do was to write to Jehovah's Witness and say, hey, this is what we're doing. And we've seen that you don't allow us to do that, but this is why we're doing it. And we believe that it would be fair use. And I think Kathleen explained what happened once we did that. So I think from my point of view is the rights of researchers such as Masakhane could be easy to point out according to the law, but practically it becomes a different animal. We've all talked about fair use and fair dealing, and more will be said, but how do we practically make that happen? We need to test it. Who interprets it? What is fair? How much of an amount is fair when we know that text data mining is huge amounts of data? And also, do the researchers understand the copyright law, even before they come to us, right? Because they come to us at a very late stage, us being a research center. We then also had to hand over to a legal firm to move some of the work forward, which didn't really move forward, and I'm happy to know that that's not just us who got stuck. And probably that's why we are here to talk about a specific right to research. So yes, they do have rights within the law, but it depends on where the copyright work is situated. It depends on the copyright owner and what he's excluding and including. And it also depends on the resources that they have to utilize to test if actually these rights that we say that they have according to the law are practicable.
Right on time. Thank you very much. So the one thing that I would like you to bear in mind for the second round of my questioning is really, do you tell them that fair use or fair dealing is actually raised in defense, that actually by the time you start talking about fair dealing, you are in court, hey, you are being sued, okay? And if you tell them so, do you sometimes see people being timid and rather deciding to stop doing the research after being informed that this is not a right, it's an exception, and because it is an exception, you can only raise it in defense when you are being sued for copyright infringement? But you can say that, you can answer that in the second round. I just want you to think about it right now. And for you, Prof. Flynn, what I want you to think about right now is, looking at your map, do you think if Masakhane were to be carrying their project in the US, applying the US law, given that when you look at the US, it's green, do you think they wouldn't have the same kind of problems that they are having now in operating in blue countries, in blue shaded countries? And the second question that I would like you to think about is, it's one thing to have a map as beautiful, colorful as this one, showing how restrictive different countries are, but it's another to translate that into like practice. Like the question being, when you look at the different laws here, does it mean that when you look at countries like US, they are more research intensive because they are open to research, and those that are red, there is less research coming out because of the restrictiveness? So because now we want to understand the impact of the laws on research output. Right, so now again, we have looked at the map, and the US researchers here looked at our laws in Africa. They have coded it the way they have, and I would like to hear from the African researcher here, who is going to tell us about the research exceptions in Kenya, South Africa, and Ghana. Are they enabling? Or are they inhibiting? Are they compliant, or are they confirming to the map that Dr. Prof. Flynn has shown here? So let's hear from Chebet, who is a research fellow from CIPIT.
Thank you very much. So generally, what we're seeing, we're carrying out a study at CIPIT where we're looking at the link between technology policy objectives in Kenya and copyright policy, that is the domestic, the regional, and the international copyright policies. And so part of our research, we're looking at what is the role of copyright in enabling an environment for modern research, such as text and data mining. So generally, what we are seeing from our preliminary findings is that, indeed, our copyright laws do allow for an exception for research. However, how this law has been written and the content in which, is it enabling to the extent of the language, or does it differ? So I'll just say generally what happens in Kenya, and then compare it to Ghana and South Africa. So in Kenya, we have our copyright law, which provides for fair dealing for the scientific research. And there's no provision that talks specifically about text and data mining provision. However, it can be interpreted that our provision would allow for TDM, but then the issue comes in what is fair and what is scientific research, because our law does not specifically state or define what this is. So in Kenya, there was a case by the Supreme Court in 2013, which somewhat went towards the extent of using fair use, and it used 6 factors, bearing in mind a Canadian case, to determine what is fair. So right now it's up in the air of to what extent does our law enable research. And then in South Africa, as we've talked about it, there is the fair dealing exception for research, but I'll talk about the Copyright Amendment Bill because this one is trying to broaden the exception that currently is there and input the fair use in the system. Then when we look at Ghana, as you've seen in the picture that was shown before, Ghana is blue. So Ghana does not specifically talk about research as an exception. And this is just to show how broad or narrow our laws are. One similarity in these 3 countries is that the Copyright Act stems from the UK Act of 1911, which provided for fair dealing. However, since then, there have been amendments to the Act, yes, but then the acts do not really accommodate the digital environment that we live in. So there's need for, yes, amendment to the acts, but more so there's need for guidance on how the provisions that we actually have. For example, in Kenya, we have scientific research as an exception to copyright. But the understanding of this, as we've talked about by other Masakhane and other members, there's not real understanding of what this scientific research actually means. So does that mean that our act is actually flexible enough to accommodate text and data mining research? We don't know. It is a bit up in the air, I'd say. So one of the things we're looking at is to see on the ground how many Kenyans actually know that they have copyright exceptions, and if they even know about these copyright exceptions, do they know to what extent that enables them? So our Copyright Act in Kenya provides that you can reproduce, you can translate, you can communicate copyrighted work, but for specific purposes. So we have a closed list. Perhaps if the act was amended to add the word such as, and this would broaden the exception such that we're not always looking to amend the act when a new development in research comes in, but it's like fair use has been called future-proof, which means that you don't have to keep amending an act when there's something new that needs to be added. So we need to look at our act. But as we've seen in South Africa, it takes a long time to amend an act. So perhaps one of the things we can look at right now is the regulatory bodies coming in to provide guidance to the users and the creators of TDM research to see how does our actual law right now enable us to use text and data mining research as an exception to copyright.
Right, thank you. You know, I'm going to take you on such as on fair use. I mean, in Kenya. So right now, as the law as it is, how inhibiting it is because it does not have the word such as. Is it limiting you to undertake modern technologies in undertaking research? So you can answer that in the second round. I just want to finish off with our the presenters here. And okay, we here to talk about the right to research. What is the right to research? I'm curious, and I think Sanya is going to quench my curiosity. And over to you, Sanya. So Sanya is currently, or was currently, was at at this institution as a research fellow. Were you the research fellow or the research chair?
Research fellow.
Yeah, research fellow in the office of the chair, the SARCHI chair of international and constitutional law. So she's the person who has the knowledge on linking copyright and human rights. And right now, she's going to refer to international instruments of the United Nations to tell us what the right to research entails. Okay, over to you, Sanya. And by the way, she's going to be joining VETS as of the 1st of Feb, so she's going to be my colleague.
Thank you, colleague. I'm sitting between two colleagues of mine, Chijioke from UP and Malebakeng from WIT, so I'm very happy to be here. Afternoon, everyone. My research focuses specifically on developing a human right to research in international law. So what we've heard from the panelists so far, much of the research on this right to research emerges from an analysis of copyright exceptions. And we know that is natural because copyright acts as a barrier, as we've heard from the panelists in the previous panel as well. But it becomes important to view research from outside the market paradigm or outside the knowledge economy created by copyright. Malebakeng made a very clear statement of the consequences of staying in the exceptions paradigm only, which is that by the time we get to defining fair use, we're already on the defense in court. But what we often forget is that copyright law does not operate in isolation, whether at the international level or the domestic level. There are several intersecting legal regimes. Internationally, we've got international human rights law, and domestically, we've got, of course, constitutional law. And my research focuses on this intersection. In particular, I focus on the state obligations imposed by the International Covenant on Economic, Social, and Cultural Rights in respect of realizing a right to research. I will refer to it as the ICESCA because it's too long to say repeatedly. The ICESCA is one of the most widely ratified instruments, treaty instruments in the world. It has 171 states parties and 4 signatories. So it really is one of the most widely applicable treaties, which carries with it obligations to perform treaty obligations. In particular, there is no right to research textually in the ICESCA, so you must be wondering what I'm on about. I locate this right within the right of access to science. So that is within, if anyone's looking at the covenant, it's within Article 15(1)(b). And I'm not the first one to do this. The right to science itself has been widely documented to be neglected in international law. Some of my colleagues like Klaus, Beiter will discuss this in more detail. But really, the point is that science is defined very broadly. I can talk a little bit more about the definition of science maybe in the comments. But basically, I argue in my research that it maps on to the definition of research. And what we see is that the definition of research etymologically is a systematic investigation into and the study of materials and sources to establish facts and reach new conclusions as a noun. And the verb is to carry out such an investigation. So really, we're developing a body of knowledge and we are conducting research to get to that research. So the definition of science is similar, but again, I won't stress on that now. Moving swiftly on to the state obligations to realize this right. The ICESCA imposes obligations of varying priority. So there are immediately realizable obligations that you can hold the state to account now without delay. And there are progressively realizable obligations. So immediately, the CESCA committee has recognized that there are deep inequalities in accessing and participating in research. And it has also clarified that states have an obligation not to discriminate, in particular on the basis of race, on the basis of gender, disability, and place of birth, interestingly. There are also minimum core obligations, so the state is bound to ensure that the minimum essential levels of the right to research are achieved at any point in time, which include the elimination of any laws that limit people's right of access to culture as well as research, and particular information in furtherance of scientific progress and its applications in a manner that's unjustifiable. So copyright law must be held up to that scrutiny. Further, states parties must ensure that everyone has access to these applications that are crucial to the realization of other rights, like the right to health, the right to equality, etc. And of course, the state is bound, interestingly, to prioritize budgetary allocations to research in areas where the need for scientific progress is greater. There are other extraterritorial obligations as well. There's an emphasis that the committee places on international collaboration. The committee also places an emphasis on big corporations, and that's something that we've been skirting around in our conversations, but really is central to the dissemination of research, the funding of research, the ecology of access to such research. So that must be central to the conversation as well. The progressively realizable obligations are that states cannot take steps backwards once they have taken steps forwards to fulfill this right. This includes the building of accessible and available and affordable infrastructure, And if states take steps backwards, for example, barring citizen participation in scientific activities or adopting laws and policies that reduce international collaboration, then they bear a very heavy burden of justification to explain why they have done that. Not only is the state enjoined to fulfill these obligations, it also has the obligations to respect, protect, and fulfill this right. So there are several sort of sub-points under this, but I will just provide the highlights because I'm aware that I'm running out of time. Thank you. So in particular, with regard to the obligation to respect, the state is obliged to refrain from placing limitations where access already exists. And this is something that defenders of LibGen and Sci-Hub could potentially consider in arguing for the sort of retention of those databases as they are. Also that the state must not pursue policies that prioritize business interests to the detriment of other rights. In particular, in respect of the obligation to protect, the state must prevent discrimination in accessing knowledge and infrastructure required to conduct research and access research institutions, and also ensure that private parties do not influence the research agenda of scientists and other researchers. In regard of the fulfill obligation, and I'll conclude here, the state is obliged to provide access to research infrastructure, including the internet, funding for research, and the preservation and dissemination of research and scientific information. This includes conservation as well as the diffusion and development of science and research. I'll stop here, but I'm happy to take any questions and elaborate further. Thank you, Malebakeng.
Okay, thank you. I think when I started off, I indicated that I'm really an IP person that likes IP, and listening to Sanya now, I'm thinking, what's the future of my discipline, copyright in particular, with this approach? I mean, how are you going to strike a balance to make sure that the industry, the creative industry, which is governed or which thrives by the existence of copyright laws, continue to exist? So that's the question for you. And anyhow, Sanya gave us a theoretical framework of the right to research. And now we're going to hear about the guide. I mean, how should governments in Africa implement this right to research? And then we are going to hear from Dr. Chijoke Okori from the Center of Intellectual Property here at UP. Over to you.
Thank you. Okay, thanks. I like that I'm coming after what Sanya has said, because the way I say it, we have these definitions of what research is, what research involves, who undertakes research, and we've found from both the conversations that we've, discussions rather, that we've heard from the first panel and us here as well, that research is for everyone, that everyone undertakes research in one form or the other. And then it led me to think about the fact that within the laws that we have, within a legislative framework, that you're talking about one branch of government, which is the legislative arm. So we would have a right to research articulated or conceptualized within a particular statute, within a particular framework, say our Copyright Act, say Copyright Act or statutes in other countries. And then we talk about the motivation to go to court, for the court to interpret these laws and tell us how these laws should apply in practice. But beyond the legislative arm and the judicial branch of government, you also have the executive, who is supposed to be the ones to implement these laws, who are supposed to be the ones to execute these laws. And so I think that the executive arm of government, which is the arm of government that I think about when I think of principles that should guide the realization of a right to research. Because the executive arm of government, in terms of carrying out their constitutional obligation to implement and execute the law, has a unique position where it is in some way legislating when it has powers within a given statute to make regulations. For example, in the decision of the Constitutional Court of South Africa in the blind South Africa case, where the court made mention of the powers of the Minister for Trade and Industry and Competition to make regulations that would solve that would address the issues that Blind SA brought to court. And the court told us that the powers of the minister to make those regulations would not address the challenges that that Blind SA wanted to solve. But there's that regulatory ambit to the powers of the executive arm of government. But there's also an interpretative role that the executive arm of government plays when they then look at the purposes behind a particular piece of legislation and think of ways to actualize or realize those purposes. And so I think that the principles that should guide African governments in realizing the right to research are inherent in the definition that we give, or that they think we should give, to the right to research, because they are our first point of call before we would even get to court. So how does the executive undertake this task? You have, for example, the Kenyan Copyright Board that is, in my opinion, quite proactive in the way that it issues things like guidelines, like public notices about things that people do. So during the course of the elections in Kenya last year, there was quite copious uses of memes that people had of political, would I say contestants or whatever, and they put out an advisory where they explained what was, to their mind, responsible uses of memes. And they've done that in other instances, even with the music industry especially, explaining what the collective management organizations should do, and so on and so forth. So there's these policies, guidelines, advisories, documents that the executives could proactively provide to the public. They might not be enforceable in court, or they might be, depending on how the policy sits, in the scheme of things under the doctrine of separation of powers. But those principles are that the executive must then conceptualize this, articulate this right to research as something that should be available and accessible to every and each ordinary citizens. It doesn't matter, whether you have institutional affiliation and so on and so forth. So those are the kind of principles that should guide them. And then principles such as reasonableness, where even courts in Nigeria, courts in South Africa, courts in Kenya, in so many parts of Africa, have said that a particular law or a particular step that you take in relation to implementing any law is not reasonable if it drastically affects a particular segment of society. So I'll stop here and maybe talk more about how, in practical terms, the executive can make this happen.
Okay, great. Thank you. So, the research from publicly funded act, right? And I think this is going to be for both you and Sanya. How do you see, because I think that's the piece of legislation in which the South African government tried to make sure that researchers collaborate and that there are no bottlenecks on access to data and so on. So how do you see this taking the right to research forward, that particular act? And again, pertinent also for both you and Sanya. The circumstances for the African governments, and I'll speak to the South African government in particular, we are already struggling to fund, basic necessities like health, for instance. So if you want to add another right here, maybe as one of the rights in the Bill of Rights, the right to research, and again, it carries with it obligations. And Sanya talked about an obligation to make sure that there are facilities for everyone to carry out the right, to enjoy the right to research. And bearing in mind that SABC only gets 3%, right? So how do you bring all these things together? How is it feasible, for that matter, financially? Because it's one thing for us to theorize, but it's another to expect certain things to be happening for African governments. Okay, so that's those are the questions I would like you to bear in mind. So finally, we have a guest, Alan Rocha. He's from Brazil. We have seen the map. Brazil is red. And there is new government now in Brazil, and which is aligned to the right to research, as I understand, the leader, the new president. So how do you foresee the right to research, happening, the outlook for Brazil? Do you think Brazil is going to change the color here, or is Brazil going to remain red? What is the situation? Thank you.
Okay. First of all, thank you very much for having me here and to be here as a migrant. So basically I'm very, very happy to be able to actually share these thoughts, and actually much more than share, listen to everything that I've been listening since I arrived here. And even more thrilled to be preceded by brilliant presentation for Black women from Africa, which we don't have a chance to hear very much from Latin America. And this is the first major problem that we have in Latin America. And I would say to Africa too, it took me 2 long flights to get here because there are no more flights between Latin America and Africa. So I had to go to Europe to come here, or either to US or to Dakar. There are no more flights, unfortunately. It would take 8 hours, it took me 24. So that's one of the things that we should definitely work on bridging.
Yeah.
To have much more dialogue. We have a lot to learn from you. Okay, we have a lot to learn from you, but mostly I have a few observations in which that's what newcomer does, observes everything. One of them is how similar our problems and challenges are. There are a lot of similarity between the challenge that we face in Latin America and the challenge I see you facing in Africa. And also how much we can learn from each other. But again, how much we don't know about each other, not only about the problems, but the solutions. So I see that a lot of the solutions end up being reinvented all the time, while we could, by being closer to each other and looking more at each other, learn that much faster, have a much faster learning period, and absorb the experience from one another that could be valuable in bringing. Because we have a lot, as I said, like the challenges are very much alike. They have slightly different colors, but they all fit in the same category as a general rule. One of them is how dysfunctional legislations are in relation to the demands and challenge that we face as developing countries. So our legislations are much more, one point is they're way more restricted than the northern developed countries' legislations are. Be that for education, be that for research, be that for artistic creation, for whatever else you point out, they are much worse. They don't fit our challenge, they're not fit for our necessities. They are basically bad copies of legislations made for others. And that I can see across the board in Latin America, and from what I've been talking to people and heard in Africa as well. The second thing, we seem to be locked into this spiral of international legislation and discourse, which actually put us in a position even worse than the legislation by making us or naturalizing the industry-focused interpretation of copyright. So we tend, by default, to consider that we can't do anything because the rights belong to the right holders and that's it. And they only belong to the right holders. And that's not true. That's not what copyright law says. That's not how the rich North has interpreted their copyright law or the international treaties. But we are still locked in interpreting them and I've seen the discussion earlier on the access to the material of, if I'm not mistaken, the TV, the national TV or the biggest TV channel around here, from what I could hear it was. That shouldn't even be a question. It doesn't matter if they get 3% of the funding. They have a concession. All TVs and radios are concessions from the countries. They have a public duty to do so. They can only be in that business because the public empowered them and allowed them to do so. So they do have a natural obligation to do so. We don't have to be discussing with them, oh, could I have excess of that because I'm not paid, the state's not paying a substantial amount. We have access to that, and we should fight for that access to that. And that change in the way we view the limitations and exceptions will only come, from my perspective, from what I can see, if we integrate copyright law, as other laws are integrated, within the framework of constitutional rights, of human rights, which demands balance in every step. That is the key thing. That's what all copyright laws are missing, balance. In most of it, and because we still have a mindset that by default, consider nothing can be done, all rights belong to the companies, and so on and on and on. And we don't challenge that. But that's one of the things. The second thing also on limitations and exceptions is that by reframing them from a human rights perspective, they are not defense mechanisms. They may be seen that in the US, but the US doesn't really care about human rights. They care about freedom of expression, that's it. That's what's in the Constitution. Social rights to education, right to all other types of human rights are not really considered there as much. But they have to be considered by us because we need them. If we don't have them, if education and culture, access to medicine, and so on is not a right, we are going to be locked again in this underdeveloped or less developed or perpetual development stage. By reframing them and seeing in limitations and exceptions an expression of human rights, we are obliged to balance them at all times. To see, so I cannot restrict an educational right simply because there is a copyright owner. There has to be balance to what limit the educational right will be restricted by copyright, and not asking what can copyright be limited on to provide for education. We need to reverse the question and make sure it gets all balanced. We got that in Brazil. That's an example that I could share. The Brazilian courts, the legislation is awful. It's awful. It was made in 1998, clearly by the industry. There was no public hearing, no public interest representation, not even RS representations. Only at the very end, they got something. And the courts, we brought it to courts. There was a case of collective management against the Catholic Church on having music at the school year, the opening of the school year. And that was the first case. You went all the way to the courts, and the courts unanimously declared that the interpretation of the limitations are extensive. Those are not the only uses possible. They may be under the written law, however, within the system, they cannot be, because all the other rights are not, the equivalent rights are not enoughly represented in the legislation. Therefore, all public powers, judiciary, legislative, executive, have the duty to balance and project human rights, all human rights that are in the case necessary to be considered, not only copyrights. So that changed completely. And from there, we've had a few other cases, mostly on the education, because it's the key point, and that really sensitized the judges and so on, mostly on education. So just to go faster and then just for a couple more things. The right to research, and to really finish, the right to research is not only the right of contemporary research. We, as developing countries, have another problem. We don't even have access to the reading material to actually start constructing the theory and abstraction knowledge to actually do the research. We have to use Sci-Hub. That's how actually research could develop in Latin America and Africa for the most part, because there were these other means. And thankfully, we are not so keen in respect to everything that people say about copyright, because most things, well, a lot of things that people say about copyright is wrong, is from an industry perspective only, and that's not correct within the framework of human rights. So that's another thing. Our problem is bigger than on the upper north. We have a right to, we need, for the right to research includes to access the material, basically papers, and that's what I'm saying, plus the data. And third, we need to go beyond legislation. We need to actually see what the judiciary can tell us about it, because every time we actually bring a real case to the judiciary, either they are going to have to be reasonable or they're going to be exposed. And when we bring them out, what happens is we see the real arguments of the industries, because there they have to really argue to what they really believe, what they really think, and what they really say. And also, with human rights, what we can do, and also bring this legislation, which are documents that they have to put there, we actually make what we are really defending. We are not defending only the free use of copyright. We are defending the free use of copyright, but also the artists' rights themselves. Because if we're defending human rights and bringing human rights into copyright, we are defending the people themselves, the human beings at the two ends of the spectrum, those that create and those that need to use it for all different purposes. So bringing human rights into copyright actually makes a new alliance between creators and users. And the industry, which has its job, has its role, and it's sure it has the right to seek profit, but it can't seek profit at any cost. There are social costs, and those social costs have to be borne by those who develop it. That's it. Thank you.
Thank you. So the only reason I gave you enough time is because more than enough time. It's because you are from Brazil.
Oh, thank you.
And your country is red. So we wanted to hear how people in the red country are surviving. So I've got two things to say. One, this is my personal use. I'm abusing the chairman, the chairship. I'm going to request the citation of the case in which the court ruled on exceptions for education. That's one. And two, I think I'm going to group you now with Dr. Samtani, Dr. Chijoki, because you just said to me now, or to the audience, that you are defending the free use of copyright. So again, what is the future of copyright law if we are to take this angle? All right, and how do you see the creators? Because again, bearing in mind the theoretical underpinnings that on this table we all know, all right, utilitarianism, for instance, that we need to incentivize people to keep on creating, all right? This is an industry, creative industry, which people who are working on it have to put bread on the table. So how do you see this balance sustaining the livelihoods of people who are in the creative industry as the creators? Okay. We will, you're gonna, yeah, so right now I think I have to, oh, you know what, I can actually go this way again. And then when I'm done, I'm going to take the discussants, and if there is more time, then we will give, I'm sure, there are one or two very hot questions from the floor that we can take. So let's hear about this balance, because I'm always intrigued by this line of argument. Okay.
Okay, the first thing is creative industry comes after creativity, after creation. So that was creation and creation of cultural expression way before creative industry. So it doesn't, creativity and creativists don't depend on the industry to exist.
Can I also say I would really like it to be lively. So
I'll be very
the three of you must talk. Okay, you must talk and like a talk show.
Sure. Okay.
So that's what I'm expecting. That if you feel something burning that you want to add, you must say, oh, hang on, let me add. You know, Alan, let me add this. Sanya, let me add, because I really, yeah. Okay.
I will provoke that limitations are not the enemies of creation. Limitations are necessary to form creators, because even though we are talent, you may be born talent, but you don't become a musician if you don't listen to a lot of music. You're never going to become a writer if you don't read a lot before. You're never going to become a film director if you don't watch a lot of movies. So these areas where you breed creators, that culture needs to be free. If it's not there, we are killing future creators, future creative works, and the industry itself. So the industry works against itself by saying the limitations are against the creators. They are not. They're just limiting their view. But that's fine. They just look at the money. That's all right. But we don't have to buy for that.
So just, I mean, I know Malebakeng, you wanted a lively debate, but I think Chijioke and I also both agree with Alan to some extent. I mean, I'll speak for myself first, if that's fine. Really here, limitations and exceptions are concerned with people who have been excluded from that market in the first place. So the blind essay judgment is very helpful here, the South African Constitutional Court judgment, because it focuses on people with visual and print disabilities who didn't have access to that market, that industry at all. So works coming through the copyright market was simply completely inaccessible. And that would mean that Christo or Jace, we'll talk a bit more about this tomorrow, but Christo or Jace could buy a book from Exclusives Books or any bookstore, but wouldn't actually have the capacity to read it because that conversion process was banned by copyright because of the lack of an exception. So really, what we're concerned with is people who cannot afford to buy books. So we're concerned with excessive pricing. We're concerned with students who don't have access, who, again, I think there's very much, it's very much a financial and class argument here. And what I will say is we can turn to analogous markets for public goods for helpful guidance. For example, in the private housing market, there's rent control legislation. In the medicines market, there's price control legislation. So why don't we have a ceiling on textbook pricing for educational materials? So that's really the sort of argument here. So it's not really about annihilating copyright. No one wants to do that. It's just about bringing people in who have been historically excluded from the market.
So you are not suggesting that textbooks should be for free. You are not suggesting that, because I thought Alan said that we are defending here free use of copyright, free access to copyrighted works. And really I'm struggling to understand how that how are you going to incentivize him to keep on creating?
Just so I think, teacher, I'm not defending let's eliminate copyright. I just say we need more limitations and exceptions that fit our needs. That's all. Sure, if you want to make money of it and create an industry, there you have to pay for all the license. But that's not about education. That's not about those amateur culture where you do in the backyard, where you do like whatever theater presentation at school. Those have to be exempted for sure, because they are right. Without them, we don't go for education. We don't develop education. We actually don't develop authors any longer. That's
because
a problem.
we are confronted right now with the situation in South Africa where we have the industry. You know, just in this week, I was looking at the entire submissions to understand where are the, where the wind goes. And I realized that we have the industry on one hand that says one thing, and then you have other industry, Wikimedia, Google and others, who would advocate for what we are talking about right now. And as a person, as a scholar, who wants to see that people have access while also making sure that the industry grows, I haven't been convinced as to that balance. Like that proper balance. Not me, actually, the industry, reading at the submissions, yeah. So I think we need to convince, the three of you need to convince the South Africans, especially the South African industry, as to the extent to which the exceptions are going to, impact them. Exactly, yeah, impact on the pocket, yeah.
I think it's a question of balance. And how you articulate that balance depends on your context as a country, depends on where things stand for you as a country. When people mention exceptions and limitations to the exclusivity of copyright or to the restrictions that copyright necessarily brings into place, people then go to the other extreme of thinking that people are talking about things being free. Remember that, for example, in South Africa, even with the blind essay judgment, the Constitutional Court made it clear that we are only dealing with people who have, persons who have visual impairment, people who have those, and they made sure that they rightly or wrongly constrained the reliefs that blind essay was seeking in that case, because the court said we still have to bear in mind that there are copyright owners whose interests are also important to put into place. The question of exceptions and the question of framing copyright exceptions or a right to research within the ambit of human rights or constitutional rights still would need to be subjected to the balancing of the rights. Remember that the Constitutional Court, again, I refer to that example because the court made the point that you are looking at how the law impacts on these people because of their peculiar circumstances, right? So when you have a right to research, even within copyright limitations and exceptions, or even within constitutional rights, you're also going to be looking at the specific market, the specific uses. So if someone like Vukosi wants to make use of the data to improve society, to make data science research for social impact, it's a completely different use from, say, someone who is going to actually make money from whatever it is that they are doing. And so that's why when you look at the fair use cases coming out from the US, the court always makes the point that, is this a market in which the copyright owner would ordinarily play in the first place? Because you don't want a situation where someone is saying, because I'm the copyright owner, every and any kind of use should be reserved for me because I'm a copyright owner. But what you're saying is, within what you have created, is this a market that you would ordinarily play in? If the answer is yes, then there will be a restriction, obviously, and rightly so. But if it's not a market that you would ordinarily be playing on, then why should we stretch the scope of copyright protection to cover that kind of activity or that kind of use when it shouldn't be so? So it's not a question of make everything free. I'm not for that as well, because I mean, I write books and I want to sell them, right? But what we're saying is, when you're writing, you obviously have a market. If a use is not within your immediate market or an ancillary, a foreseeable market for you, copyright protection shouldn't be broadened or extended to that kind of use, and that's just, I think, what we're talking about.
Okay. Right, thank you. I think I would like to close it with I just want one, Sanya, if perhaps you may, talk about the funding model of the right to research, especially on the obligation of the states, the right to, the obligation to fulfill, the feasibility of it.
Thanks, Malebakeng. Yeah, just a few sentences on that. So quite a lot of the way the state the ways open to the state to fulfill this right to research, quite a lot of those are not intensive financially. For example, once the copyright law is passed, hopefully, you will see that, if we take a very concrete example, all of us watched the UCT fire with a heavy heart, and we saw that a lot of the collections of that Jagger library were lost forever, rare manuscripts that hadn't yet been digitized. The reason for the lack of digitization was unclear copyright exceptions, amongst other things. But really, a change in the law can completely change people's ability to do things, and all that needed was a change in that law. The Copyright Amendment Bill has that in Section 19C. It allows libraries to digitize their works. And that already is fulfilling the right to research. So that's a non-financial intensive way of fulfilling this right. So that's one example. Another one is obviously, and maybe we can move to the discussants, because I'm sure Klaus has a lot to say about the extraterritorial obligations of states in respect of global North and global South cooperation in seeking funding to fulfill rights in the ISESCA, and also the slightly more tenuous obligation of global North states to respond to that request for funding. But I'll stop there for now.
Okay. Thank you very much for the interjections. Okay.
To answer your question, if there is no room for growing the desire to buy books, watch films, and whatever, there will be no customers at the end. That's why we need to have this space of formation free, like education.
Okay, great. So can I turn my back against you and then look at the side? Yeah. So let's hear from, what I would like to hear from you now as indicated. So we saw the map. You have worked specifically, intimately on the South African law, on the Ghanaian law and Kenyan law. So what do you think? Do you think the results that we have seen, the map here depicts what you have encountered on the ground?
I think I can take that one.
Yeah.
So from the map, we see that Kenya is green, and from that map, we see two or three countries in Africa are green. So Kenya being one of them, it shows that Kenya has a very open exception for research. So as our law is, indeed, it's pretty open in the sense that we allow for scientific research as an exception. However, I think the issue or the challenge is beyond the flexibility of this law and the implementation of the law. So the challenge in Kenya is, yes, the Act allows for scientific research, but there's lack of cases, so there's no judicial interpretation of what that scientific research is, to start with. When it comes to fair, the definition of fair, we have a case, as I talked about, which gives factors on what can be fair. But it depends on who takes what to court. Is their modern research actually going to be in line with the Act? At the moment, we do not know. And so we need either for the Act to be broadened, that is why I was talking about using such as or making it fair use, or we need a specific exception to cover the digital environment that we're living in, such that we are not always being in a state of we don't know if this applies or it doesn't apply. And so this is what we've seen with the users of TDM, and the question still remains, we don't know. In the case of South Africa, we've seen in the map it is blue. If and when, hopefully, the Copyright Amendment Bill is allowed, then it probably would become green, because then it would become very broad and modern research would fall under there. For Ghana, we see that it's blue because, one, there's no specific express provision for research. So at the moment, as we were saying, we don't know if TDM or if the new modern research methods that will come up will actually fall in line with the exceptions. Yes. So I think at the moment right now, for Kenya, it's not a state of is the law flexible, it's how is this law being implemented to be actually used by the people who will be using the modern research.
Okay. Yes, you still remember my question?
Yes.
Say, yeah.
I can jump in there because practically it's not, I would not say that it's actually granting rights to researchers such as Masakhane, because even as they came to us, I am an alumni of Stellenbosch, but I have not broken any laws, so I did not advise them because I'm an academic. Maybe I should start breaking laws now that there's precedents before me. What we did is to first speak to them about copyright and the exceptions, right? We had to start there, which I don't think is fair, because it means developers have to first learn about copyright law. Why can't we learn about how developers work, right? Maybe it's easier, I'm just saying. But it means that the environment is already not fair for them to understand these things. So if it's so difficult, like Chebet is saying, to give a straight answer, Kathleen came to me and is like, does the law allow me to do this? And then my answer is, it depends. Because practically, the solution is, it demands a lot of, financial power, a lot of time and dedication from an advocate who understands that we need to push for this exception to work out. Now, the developers...
And what was their response? The moment you say it depends, does it not have a chilling effect?
It's confusion, first of all, because also they might think maybe I'm not competent in what I'm saying, because how is it in the law? But then the answer is that it depends, right? Because even, I'm sure there are lawyers who would look at me and say, why am I saying that? I'm talking about the practicality of it. Because I do not want a situation where they don't get the result that they want. As much as we are saying, let's test it, let's have the court interpret it. Does Masakhane have the funds to go to court to have it interpreted? Do they have the time? They are also researchers like us. They have to have results of the research that they're doing. What makes practical sense for them? However, if we had a right that was clear-cut, that said scientific research, including text data mining, right, would be an exception, then it would be very easy to give that to them. But now I had to go beyond the steps of being an academic and not yet being an advocate of the High Court of Kenya, and sort of now give them an understanding of copyright law, give them an understanding of the practical situation that they're in, and then listen to the solutions that we can come up with together. And that helped them in future projects, but not in that particular project. It helped them in future projects, but it also brought us here today to have this discussion about the right to research. Mm-hmm. So I definitely think that though the law in Kenya looks like that, I wouldn't say it's green, because that is what it is on paper, but practically on the ground, we don't have, Kenyans are litigious, let me not lie, we are litigious people, but having the funding to do that, it would be interesting. Even those who are asking Vukosi to sue, are you going to give him the funds to sue? Or are we just expecting Masakhane to come up with funds to do that? Maybe that's also an area of research that we could think about, of testing it, really interpreting this in the courts. And who is sitting in the courts to understand how to interpret? Which school of thought are they coming from? So I think there's so many steps that would take us there. So the answer is yes, I explained it, but it was not a satisfactory answer. Practically speaking, it's a mess.
Okay. Finally, yeah.
Can I just jump in on that one? So, because I think this is bringing us, back to this question that to some degree we started with, which is what are the tools that we have? What's the problem and what's the tools that we have? And so on what's the problem, there's a balance, if you will, or a tension even between flexibility, that future proof, is the text of our laws open enough in order to adapt to new purposes on the one side, and clarity on the other. Is our law clear enough that our researchers or whoever will know that they can do what they want to do? And that's very context specific where you want to go, because their intention, the more clarity you have, the less flexibility you're going to have, right? If your research exception says, if you're a text and data mining researcher, you can use a computer to do computational analysis of scientific articles. Well, it becomes very clear that you can do that thing. But then what about other things? Can you share materials with a research collaboration? Well, you don't answer that because that's not text and data mining. But if you have kind of an open, broad research exception, you're going to have a lot of potential flexibility, but you're going to lack that clarity. So what can we do? And at the table here, we've gone through, I think, a whole bunch of different tools that exist, right? So one, at the highest level, you could have international law, you could have a treaty. The agent there, so there's actions going on the African Continental Free Trade Agreement. It's one kind of treaty. This issue is coming there. There is a forum in the World Intellectual Property Organization, and research is on the agenda there. So these things could be clarified. But then you must ask at each of the forums, well, what can we do? So on those issues, you have a ton of different countries. You're going to have to reach a consensus. Maybe you can focus on the cross-border issues or something like that. Then coming down, the courts, you could have litigation. You were speaking about litigation, right? You could have affirmative litigation. Vukosi could sue. Or you could have defensive litigation, right? Vukosi could do. And then you just wait, right? You make them sue. But do they want to sue? They have to go through the same kind of risk analysis that Vukosi does. So Vukosi could just do it. And maybe he needs a backstop. Maybe he needs a clinic or something that says, well, if you do and you get sued, we'll help defend you. But the other side faces risks as well. They don't want to create bad law. Do they really want to sue a nonprofit researcher in a university that's creating texts for Africans to read, scholars? So Vukosi, do it, man. Let's bring that case. For real. Where's the publishers? You're going to sue him? For real? I don't think so. And then that pattern becomes the lived action, right? It just becomes the action on the ground. If everybody is doing it and nobody is getting sued, the suit won't come in the future. Legislation, right? So your parliaments can clarify or increase flexibility in the law, and that's a choice. You can do both. You could have a broad open research exception, like Nigeria, but you could add on to it a text and data mining exception, such as, research for all these purposes, such as computational research. You could do that. And many countries have. I think it's, no, I'm lost. So many countries have, but none in Africa. Many countries have clarified that research includes information analysis, computational analysis, text and data mining, whatever, different ways. Many of them only non-commercial, some of them even commercial. You could do it. No African country has done that yet. You have flexible exceptions in various places. You could have more specific exceptions. Chijoke was saying, well, the executive can move without the legislature, especially where you have an open exception. You could have guidelines, regulations. Copyright offices could say, as we interpret research, it includes these things. So they could do that. And then finally, the private. In addition to just doing, you could create what many creators in the US have done, best practices statements among the creators themselves. So in the US, digital researchers have done this, libraries have done this, documentary filmmakers have done this. Lots of communities have come together themselves with lawyers helping them along and saying, we think these kind of things are fair. And we think, so as researchers, as natural language processing researchers, as digital researchers, could come together with lawyers sitting at the table and come up with some guidelines. We think these 4 or 5 things are fair. We think if we're only using another work for the purpose of creating a tool, not for republishing that's fair. We think that using an article only for the purpose of extracting information from it is just about finding facts and that shouldn't implicate copyright at all. You could come up with those things and you bless it and people do it, you're much less likely to receive that suit at the end of the day, right? So in other words, there's things all of us in this room could be doing, whether you're a researcher or a policymaker or a judge or a lawyer. There's different ways to attack the problem.
Okay, one of my questions is still pending. So the impact of your map, in terms of creativity, does the color really matter? So is Brazil less creative because they are red?
Brazil is very creative, but there is less text and data mining research being published in Brazil than other places.
Okay, that answers it all.
So, I mean, the short answer to your question is that we've done some empirical research on this issue. Mm-hmm. So we've hired some economists to do econometric work and look at whether changes in the law have any effect on published scholarship. And what you find is that essentially it does. That as countries open their research exceptions, more academic scholarship is published in those countries, controlled for other factors like population and whatnot. So it's kind of self-evident, but if you allow researchers to do more, they will actually publish more research at the end of the day. So countries with more open research exceptions tend to publish more scholarly research. Okay. That's what it shows.
Thank you. So finally, I'm going to move to our just one discussant who is here, and then I'll take in 2 minutes, if you can summarize in just 2 minutes.
Okay, thank you to the panel. I want to focus on a question of what the role of the industry is. Now, the industry clearly has a role when it comes to entertainment, filmmaking, music, mainstream publications. But is there a need to preserve the role of industry in the field of research just for the sake of preserving it? There's no constitutional guarantee of any type of industry. UNESCO's recommendation on open science of 2021 calls for open access. It still works with copyright, but it works with models of gold open access and green open access. So we should perhaps be even more deconstructive and question the role of copyright in the field of science. This is perhaps sounds like, is a guy mad what he's saying? But already at the time of drafting the Berne Convention, there was a question whether scientific work should be included in there. Because if we are honest about it, how does the publishing industry in the field of copyright work? We as researchers write something, the public pays. We donate the article to the industry. The industry asks peer reviewers who do it for free, the review. Then the industry sells it back to the university, pays a lot of money. So the university then pays a second time to collecting societies. Deutsche Bank has called this kind of model a pay thrice model. That is the public funding. That is where it goes. So authors like Reichman and Okediji say the role of industry in research today is siphoning off public funds to the private purse. That is where the money is. So we need to question the role of the industry in the field of research. And there's people recommending that the publication function today, because it is digital, can be taken back by academia. To mention an example, in my own university, we've got the Potchefstroom Electronic Law Journal, open access. The work is done by the academics. It is free for all, and it is a good journal. It is ranked among the 3 best law journals in the country, so it does work.
Can I come there? It's not for free.
Okay,
Yeah.
but that is like covering cost. That is not to make a profit, because if you look at the big companies like Taylor and Francis, Springer, Elsevier, they have got a profit margin of over 40%, which is more than Apple in the field of research. That is where our money is going, because what are they doing? They are converting a Word file into a PDF file. If I want to buy it back as an academic, I won't have to pay for gold open access. I have to pay £3,000 to buy back my own article and to distribute it. This really does not make sense from a perspective of the right to research.
So it seems like Ben also wants to interject there. So I actually wanted to say it's not for free, and I think this also takes us to think about funding models for copyright. And we can't talk about for free because they are not for free, but we need to think of funding models.
And I have a comment about that, but obviously I'm also just getting my own back, Malebakeng, because you spoke in my session. And that is to say, it's an extension of what Klaus has just said, but to the sector of film, television, creativity, and all of that. I don't know when the gentleman who's here from the Nigeria Copyright Office is making copyright policy. Maybe he's thought a little bit about whether it would be an objective of the Nigerian government and Nigerian society to have African streaming services, African platforms where African content is purveyed to the public, as opposed to the market being dominated by several streaming services all based in the United States, which is the present situation. Now, copyright wouldn't be the only or necessarily even the main tool to go about indigenizing or promoting local production, local creativity, platforms for local, a business model for Nigerians or anyone else in Africa to do that. But it might be one tool you could use. We used IP laws, of course, in South Africa, as we all know, to ensure that multinational pharmaceutical companies lowered their prices. We just talked to them about the possibility that we would change the IP framework, and they then lowered their prices. Now, if you look at the Copyright Amendment Bill as it's currently drafted, fair use, which we've been talking about, says you've got to transform. You can't take somebody's work and use it for free, ever, because it would be a substitution in the market. On the other hand, you can't necessarily do what Michael Markowitz was saying might have been going on at the SABC, which is to say, well, you've got an idea of how to use my stuff. You want to transform it. I'm going to speculatively say there might be some income for me in your idea. No. It's probably fair use at that point if it was your idea to transform something, and it might affect industry. So maybe my last word to say, Malebakeng, you were saying we have to convince industry. Yes and no. There are some industries we may never convince. We may have an objective within copyright reform to allow industry to evolve, to change for the benefit of our society. We may want to convince some. Others we may say, adapt or die, be part of the new society we are trying to create with more equal open access. Thank you.
Just on this idea of gold open access, which is advanced as a solution today. The thing is, it might work for European researchers or US researchers, Canadian researchers. The problem is in South Africa, the researchers at universities don't have the money to pay it, and the university will also not cover the costs. So open access publishing becomes a right reserved to the rich countries. So it's another case of discrimination that we should keep in mind. That's my last thought on this.
Okay. Oh, thank you. Yes. So, Sir, let's start with you.
Thank you. If we look at the right research, then so if we look at the right of research from a human rights perspective and copyright, I think in South Africa we have a problem with very old access to information legislation. PIA is more than 20 years old. Just a few examples. One, it's very weak on proactive disclosure. If you, for instance, look at the African model law on access to information. Two, if you look at the kind of formats of information that falls under the legislation, again, if you look at some of the instruments from the African Commission on Human People's Rights, you'll see that in later declarations and other soft law, there are many more formats covered. Three, universal access to the internet to access information, proactive disclosure. And maybe a last example about the need for electronic records management. And also the lack of open data standards. And I would love to hear what the panel says about the reforms required in the promotion of access information to ensure the right to research in line with the copyright reforms. Thank you.
Okay. Thank you, sir. It's going to be for your side. Okay, let's move. There is another one here. Yes.
Thank you very much. So I'm Jonathan Band. I represent library associations in the United States. And so two quick comments. One is just reinforcing Sean's point about all the different avenues for advancing the right to research. So given that the open models can be ambiguous, there is, I just want to give a concrete example that just came out last week of a government that decided it was going to provide some clarity regarding its fair use provision. So the Israeli Ministry of Justice was, people in its industry that were developing machine learning were a little concerned. Is ingesting all of this vast amount of material, is that a fair use under Israel's fair use provision, which is based on the US provision? And the Ministry of Justice came out with like a 30-page long opinion saying, kind of looking at the issue and concluding ultimately that it would likely be a fair use. Now, that's not binding on the courts, but obviously an opinion of the Ministry of Justice would be pretty influential on the courts. So that's the kind of thing, very concretely and exactly on topic of how a government can explain when it would be fair use, but it also gave some examples of when it thought it might not be fair use. So again, I think that's a helpful example. Then very quickly to the issue of how do you find balance with exceptions. I think at the very least it has to be the case that in terms of balancing the interests of rights holders and of industry as opposed to the general public, that the level of exceptions in developing countries should be at least as high as in the most developed countries. So if in the United States we have a thriving film industry and a thriving music industry, with all of our exceptions, it's obviously having those kinds of exceptions is not problematic to the functioning of an industry. And so it seems that, that the level of exceptions in the developed countries, that should be not a ceiling, that should be the floor that developed countries should be looking at. They should say, okay, well, at a minimum, we should have what the EU has and what the US has, and then, okay, how much more do we need to adjust that given our unique developmental issues and so forth. So those are my 2 comments. Thank you.
Okay, thank you very much. So let's move to, yes.
Thank you. I'm just going to speak briefly to the question of balance. And I think that when we are having that conversation, first, I agree with what the panelists have said so far. But when we are having that conversation, I think we should rather emphasize that it is not a case of we versus them. In other words, it is not a case of researchers versus authors. I say this because authors themselves are researchers, so they must be included as beneficiaries to the right to research. And when we do that, in striking the balance, we should look essentially to the human rights framework, not necessarily copyright, because the human rights framework already has section 15(2) of the International Covenant on Economic, Social, and Cultural Rights, or 1C, already gives authors the right to benefit, to material and economic benefits, to moral and material benefits from their creativity. But if you look at the rights strictly, there's really nothing specific except broad for authors as researchers, okay? The right to access, creative outputs that is already there in their creative endeavors. So when we view it from that angle, we could see that the right to research is not a case of we versus them, but a case of actually striking that balance. If that right is recognized either as an explicit or an implicit right. Thank you.
Okay. Thank you. Mr. John, up there.
Yeah. Thank you so much, Madam Chair. Mine would just be a footnote to the comment that was made by Ben, because he mentioned Nigeria, and he made asked a rhetoric question. But I take that as a very positive comment, and I think countries should find ways of not just changing their laws, but also making the law work for them. And I don't think any country should be apologetic if you put in place such structures and such frameworks that will make your country or your region to be able to take advantage of the flexibilities of the provisions of the law. But one thing I know is that the other countries will always push back. It's interesting, and I love what I think Alan made that point on the need for balance and the need to draw those boundaries without having to explain, as if the exceptions are the ones now looking for space. The copyright law itself is most always defined around boundaries, and the exceptions are supposed to be inbuilt with a balance. So as far as the Nigerian situation is concerned, for instance, I think it behoves the regulatory bodies, the administrative bodies, the copyright offices to do more than just making or helping to make the laws. And despite the pushback, we can always find examples in those countries where they are pushing that they also do the same thing to ensure that their industries are protected and they take first and full advantage of the provisions in the laws. So this is a lesson for African countries to use the copyright system first and foremost for their own national and then regional interest. Thank you.
Thank you. You know, from what you have just said and from what Mr. Band have just said, Sean, I would like to pose a question to you. You talk about countries should be able to draft legislations and to put structures that enable them to, you know, to benefit from copyright laws. And then, Mr. Band, you indicated that, you know, U.S. has wide exceptions, thriving industries, and so why should we be afraid of exceptions? I mean, looking at the U.S. But South Africa is trying to copy from the U.S. There is a pushback from the U.S. as one reads newspapers about, because one of the countries that forcefully are very unhappy with our draft bill is the United States. Why is that pushback, actually?
So you remember your, International Politics 101 course, no?
Yes.
And countries advocate on behalf of whose interests? Their own. No, their own interests. They don't advocate on behalf of the other country's interests, you know? So fair use is known as like the secret sauce of technology growth in the United States. It's very useful for the United States. Nobody's trying to get rid of fair use in the United States. And those that don't like it are still not trying to get rid of it because they know it's there. It has so much support. For sure in the library and education systems, but also in business systems as well. But it's not necessarily in the US interest for everybody to have fair use. You don't want everybody to have the secret sauce. Then you're on an equal playing field. You want to be on as unequal playing field as possible. So the United States supports fair use in its own country, but it doesn't support fair use for other countries. It doesn't want everybody to have that own flexibility. So it makes the argument that fair use is good for us, but it's not good for you. And that's literally what it says. It's okay for us. Why is it okay for us? It's okay because we've had it for 300 years, and you're just doing it now. So that's the difference. It's okay because our courts have been interpreting it for a long time, but your courts have not. So that's why it's okay for us and not for you. But you have to look at each of those things. Do you think your judges don't have the ability to interpret the word such as? It's in some of your other laws. It's just not in your copyright law. Do you really think that you can't adopt something that's been had for 300 years in another country but is new here? What problem does that do? We do that all the time. When South Africa amended all of its laws after 1996, it adopted all kinds of laws from other countries. It's competition law, it's fair trade laws, so it does it all the time. So that's a good question. Why is it that the United States thinks that fair use is good for itself, but not for you?
Thank you.
Okay. Thank you very much. I wanted to thank all the panelists for your insights. I learned so much by listening to you, and I'm really appreciative. As you were talking, I thought about one idea for the future. And when we look at commercial publishing and what the commercial publishing industry is doing and where it might be in 5 or 10 or 15 years, I think we see a shift from the sale of copies of journals or even journal subscriptions to a business model where the publishing industry itself bases value extraction on text and data mining. When you go onto Scopus or Web of Science and you're engaging in these databases, the real value is not providing you the PDF file or the HTML file. It's their recommendation engine. If you read this, you might also like this. Here are 10 other sources related to your research. And I won't be surprised at all, and if 10 or 15 years, that's the predominant business model in academic publishing, in the research sector, that the value they derive comes from text and data mining. And if that's possible, I wonder how we might think about different kinds of strategies and how the stakeholder positions might evolve as the publishers themselves realize how important text and data mining is for their own future viability. Wonder if the panelists had any thoughts on that.